partners here at Altitude Community Law. What you should see on your screen is the PowerPoint presentation in the center of the screen, and then down at the tiny bottom there should be me. Keep that as tiny as possible. On the left side of your screen you should see a menu, and there is a box with a question mark, and then if you have any questions, please feel free to put them in that box, and I will try and remember to check them and answer your questions. Sometimes I get on a roll and I forget to do it, but I will come back if I do. CMCA credits are automatically generated once the webinar hosting site provides the attendance confirmation of your names to our office, and they will be sent via email within about 48 hours following the webinar. These credits aren't transferable. If you have any questions or are having any kind of IT issues, please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about technical issues you're having trying to get logged in or about your CMCA credits. The webinar is being recorded and will be on our ACE YouTube channel later on after we're complete. So let's talk about what we're here for. We're talking about proving a violation. So somebody says you got a violation, and we're going to talk about the steps that it takes to actually prove it. Many years ago when I was a district attorney, opposing counsel would always tell every jury we walked in front of that she was from Missouri, which is the show me state. And she would ask every juror to hold me, the prosecutor, to show them and prove to them that something happened. And every time anything would pop up, she'd remind them, come on, be from the show me state. So let's talk about how do we show something? How do we prove to a judge? Because when we're talking covenant enforcement, the case is going to be tried to a judge. So how do you show the judge something really happened? So let's think about what we're looking at. It's a lawsuit, right? We're talking about how we're going to present this. Now, obviously, you can look at some of the information about what you should do in your hearings as well, but let's kind of think about this in the terms of a lawsuit, right? We're going to be looking at the law of what I'm allowed to do. We'll talk about rules of evidence as we go through this. We'll talk about some of the obligations I have by the county court rules or the district court rules. We're definitely going to talk about the governing documents and whether or not they can help us prove this. We're going to talk about your rules and your policies. When we start talking about facts, we're talking about a witness testimony, we're talking about a photo, we're talking about a document, the letters you send out, we're talking about videos. Sometimes we need expert opinions. That's rare in most covenant cases, but it's not unique at all when we get into district court cases. So when we're defending a lawsuit, we're often going to look to experts. And last but not least, we're really not going to talk about the emotion of it. The emotion of how frustrated or somebody is with something, it doesn't help us prove it. And we always have to try and push aside and divorce out the emotions to try and really look at the facts that we have in front of us. As managers, board members, you guys have that hurdle of getting past the emotions of your homeowners. And a lot of times your answer when you're talking about a lawsuit actually might just be, I can't talk about it, it's with the attorney. And that's in your favor because realistically, you don't want to get into the issues with people who are not part of the lawsuit. But again, they're working on emotions because this is their home, right? Whatever's happening that they don't like, they're going to be looking at it most times from an emotional standpoint, not necessarily from a factual evaluation of the case. And that's what you're going to have to do. So when we start looking at this, we're going to take this in steps to try and help make it clear so that we all are on the same page. So what's the first step when, and I'll probably date myself here, when Mrs. Kravitz comes up to the board or the manager and says, the neighbor is doing X. First things first, you have to find the rule or the covenant that was violated. I cannot tell you the number of times that I have gotten handed an email from a homeowner that was sent to the board of make them stop doing this. And my response back to the board member or the manager is, I can't. There's nothing in the declaration, there's nothing in the rules that prohibits it. You have to look very, very bluntly. If you have a homeowner who says the neighbor is parking their car in the front lawn, you need to stop that. Okay, pull out your declaration, look at your covenants. Do you see a rule that says trucks can only be parked on the street, can only be parked in the driveway, can only be parked on a hard surface, must be parked in the garage? Do you have a rule that says where the truck has to be parked? Do you have a rule that says where it has to be parked? A resolution. You have to narrow it down and come back to, is there a rule that prohibits the conduct? And if there isn't, your response back to the neighbor is, I'm sorry it bothers you, but I can only enforce the covenants, and the covenants don't have anything that prohibits that conduct. So that's step one. You've always got to go there. Next step, does the action truly violate the rule? Didn't we just cover that? No, let me drill down. What if your rule says the association encourages irrigation and they didn't put in an irrigation system? It's not a violation. Somebody being encouraged to do something, well, that might be they should, and you'd really like them to, but there's nothing that says they must do it. Next thing, sometimes you have people who say the parking in the wrong spot, right? You allow parking in the front of the house, and this guy's parking on the side of the house. Well, and you're like, well, it says he has to park in front of the house, and he's not. Now you have to go to your documents. Do your documents define what's the front of the house? Does it say that the actual front of the house starts at the corner? Or is it in front of the house if just a small part of the truck is in front of the house? You have to look to the specifics sometime, because you have to know that the opposing counsel is going to be very clear and say, oh, no, part of the truck is in front of the house. There's nothing in the rule that says all of the truck has to be in front of the house. Part of it is. Or there's nothing that says where the front of the house starts. When that's the issue, what you want to do is you want to look to your board and say, hey, let's amend the rule. Let's define front of the house. Let's be really clear about it. Is it going to delay your enforcement? Absolutely. But don't go to court if you can't win, because remember, we're going to get to this, but losing party pays attorney's fees. And so we want to make sure that we actually have a violation. So if that means you have to take a step back, amend your docs, define it, then do that. I have a question. The question is, covenants say residents must follow the law. Neighbors want the HOA enforcing local law like drug dealing. All right. That issue comes up. It's not an uncommon one. What I always recommend when that issue comes up is that you say to the homeowner who wants you to enforce that covenant, great, you think the neighbor is dealing drugs. Call the cops. When they cite him for drug dealing, because they're the experts, we are not. When they cite him for violating the law of drug dealing, I'll be happy to send a notice to him that he's also violating the law. What probably is going to happen is they're then going to say, well, we want you to get rid of him. And your answer back to them is going to be, if he's an owner, even if he's convicted of drug dealing, I'm not getting rid of him. I cannot force an owner to sell because he's violating the covenants, right? So you need to be clear on that one. If it's a tenant, you can in fact then go to the landlord once you've got that citation from the attorney. So just remember that, yes, your covenants might say the local law violation is a violation of the covenants, but when the cops say it's a violation, then we'll send a violation notice. What about general rules that could qualify for many things, unsightly conditions. I consider unsightly condition to be the same as nuisance. It is extraordinarily unclear and it's very difficult to deal with. I highly recommend that if in fact the word unsightly conditions is in your covenants, that you work with one of the transactional attorneys to create a more specific rule, because unsightly to one person might be just fine to the judge. And you don't want to find that out in the courtroom. Okay? So let's look at some examples here. Owner doesn't paint their house. Now, most of us would think, well, okay, that one's simple, right? You're going to go to the documents and you're going to find the rule on maintenance. Here's the problem. There are a lot of old governing documents that presumed all owners would take good care of their house and didn't put any requirements in for routine maintenance. So if in fact you have those old governing documents, you need to work with your board and your attorney to make sure that you can draft a rule that clearly sets forth maintenance obligations, okay? Don't presume that, of course, I can just write him a letter and say he didn't paint the house. If you don't have a rule, you don't have a covenant, one of the two, that says owners must maintain, owners must routinely take care of their home, something to that regard, you don't have the approvable violation. Account already went through the truck violations, and again, it's one of those that frequently comes up, where they can park, how they can park, and you need to look at your list and say, look, there's no covenant that prohibits what they're doing. Okay, painting without an architectural form. Oh. To be clear, an architectural request form is not for the benefit of the HOA. An architectural request form is for the benefit of the homeowner. If I'm the homeowner and I submit to the board that I'm going to paint my house Bronco colors and they sign off on it, when my house is painted, they can't make me change it because they signed it. That I'm protected when I submit the form. If a homeowner doesn't submit the form and paints their home a beautiful color, you win. The home's painted and it's beautiful. Who cares about a piece of paper? If a homeowner paints the home a color that is not allowed and they didn't submit and didn't get approval, then sue them for painting a color that's not allowed. That piece of paper that everybody gets wound up about, there's no architectural form, there's no approval, that paperwork protects the owner. It's not about protecting the HOA. Okay. Remember, statute of limitations. Don't let this bite you, okay? If you have somebody who paints that house, and let's go back to my colors, they painted it Bronco orange, but they didn't get approval. You have 1 year from the date that they painted it to take it to court. And I know the statute says knew or should have known, but proving a covenant violation means part of my proof to the court is the HOA is harmed by the violation. Okay? If you can't see the violation and you want more than a year because you didn't see the violation the day it happened, then it didn't harm you. So trying to prove to someone, to a judge, a year and a half after the fact that it's okay, we didn't find out for 6 months that they painted, yeah, you might get past statute of limitations because you didn't see it, but you just lost the case. Because if you couldn't see it for 6 months, it didn't hurt you. So I will go back to my first sentence. You have 1 year from the date it's painted to get it into court. Fines, liens, hearings in front of your board do not extend that. 1 year, that's it. You don't get it in a courtroom 1 year from the date they painted. statutes of limitations will bar that lawsuit. Okay. A couple questions popped up. What if the homeowner painted the home and the board approved the color, but then decided they didn't like how it turned out? Too bad, so sad. There is a defense called estoppel, and that defense in courtroom says if I, the owner, go to somebody who has authority, that'd be the board, and they sign off on it, they are estopped from complaining about it after the fact. So once they sign off on it, it's done, it's over. Next question was, looks like it was painted and the house was sold and the board wants to pursue the new owner and force them to paint it a different color. That's going to depend on the specifics of the status letter sent. And if the status letter sent did not call out the violation, you're probably out of luck, because a status letter is also referred to as an estoppel letter. What is the status of this property? Has it paid what it's owed? Does it have any current violations? What is the status? And if you didn't say there's a violation and it transferred to a new owner, there's a very good chance that you cannot go after them now. That's going to be a case-by-case basis. You're going to have to pull your documents and probably talk to your attorney about whether or not you can deal with that. Okay, we're getting way off target. There's a question from somebody about a management company and what the board's talking about the management, and we're getting way off into the weeds. We're trying to focus here on proving a case. So how do you prove your case? And you prove your case by starting off and making sure you have a violation and making sure that you're within the statute of limitations. Because if you're beyond the statute of limitations, we're never going to get to court anyway. So let's look at the third step. Have you followed your procedures? Remember, if your documents, and you all have covenant enforcement policies if you're Kiowa communities, so if you have covenant enforcement policies that say you have to send 3 letters before you turn it over to a lawyer, you have to have sent those 3 letters. If you didn't send all those letters, there better be a deviation clause and there better be good reason to deviate, or the court is going to say, why am I enforcing on the covenant violation when the board can't even follow their own policy that they wrote? Okay. Whether or not you have the hearing on fines, it's gonna come up. Can you continue fining during the time that you've given it to the lawyer? And that is yes, you can. Most of your covenants and most of your governing documents are going to say that none of the remedies, meaning the fine's a remedy, the lawsuit's a remedy, none of the remedies are have to be just one or the other. You pick one or the other. Exclusive. You can. They're all cumulative. You can use all of the different remedies at the same time. Sorry, I have another question. Sorry, my screen blanks when I go to the different areas. What if beyond the enforcement policy, is there anything further the HOA needs to do to take action, to have weeds removed, fence stained, house painted, to back charge the owner? The owner is responsible. That's going to be specific, document specific. Whether or not you can charge the owner, whether or not you have the right to go on their property and do the work yourself. The term of art to do that, if you're going onto somebody else's property and fixing a violation, is called you're going to abate the violation. And whether you have the right to abatement is going to be specific to the governing documents. Whether the right to charge back is going to be specific to the governing documents. Okay, let's continue on. So we've got hearings, fines. You want to make sure that you're following the procedures. What happens in that circumstance, and we've all seen it, turn around and you sent a letter and you put it on hold for a period of time for whatever reason. COVID was one of the big ones. A lot of things got put on hold. You started picking them up again, and you went, oh my God, 1 year is going to hit, and it's going to hit in 2 weeks, and I haven't got all my letters out. What do I do? You can go ahead and get that to court. What's going to happen is you're going to turn it over to the lawyer. Lawyer's going to file the lawsuit and get it filed in court. Then the lawyer's going to put it on hold. And during that hold period, you're going to get your letters out as fast as you can until you get all the letters you're required to send out during the policy, right? So if you had to get 3 letters out and you'd only gotten 2 of them out and you're about to run out of statute of limitations, you're going to get the lawsuit filed. Won't be served on the homeowner yet. It's just filed. Okay, so we've met the requirements of law. You're going to get that 3rd letter out. What happens if he fixes it? He fixes it. HOA is going to have to eat the cost of that lawsuit because you can't make the homeowner pay for it because he fixed it following the policy. But it's the only way to protect you in case he ignores the 3rd letter like he ignored the first 2. So just be aware, you've got to follow your own procedures, okay? 4th step. What can we bring to court to show we actually have a violation? How do we prove it? Well, a lot of times we're going to look at photos. Photos are probably, the first thing that comes to mind to prove something. Now, not every violation can be proven by a photo, but a lot of them can. So we're going to work through that and look at some examples. Testimony. Testimony of a manager, testimony of a neighbor, testimony of a board member. All of those are valid documents. They're valid pieces of evidence. A lot of times I hear people say, well, I couldn't get a photo of it, so we can't go to court. I've had cases when I was a district attorney, and the only evidence I had was a witness, but it wasn't a witness. I had somebody willing to come testify in court under oath and say what they saw. That's valid evidence. Don't discount that if that's all you've got. It is valid evidence. Obviously, we like more, but it's something that you need to look at in every case and kind of evaluate the weight of the case. Recorded documents and non-recorded documents. We're going to talk about both of those for different reasons, okay? The issue is, what can you do and how are we going to do it? Now, I want to pause here for a minute, okay? When you have that lawsuit and you're ready to move forward and you're ready to turn it over to the lawyer, that's the period of time you need to go do research. You need to pull every letter in your file, every photo in your file, every email from the homeowner, every letter from the homeowner, every document that they had. Because the law requires that both sides to a lawsuit have to provide the other side with copies of documents. If you don't provide those copies of the documents to the other side, minimum in county court, 30 days in advance of that trial, you can't present it at court. It does not come in. So if you sit back and wait and show up in trial with your 2-inch folder and say, here's everything, see, I've documented it, I got it. Too bad. We can't introduce it. You have got to pull that stuff early, get it to the lawyer so that they can provide it to the other side. Because if you don't provide it, it's not coming in. Okay, let's take a look at this photo. This photo was provided to show that, in fact, a homeowner was driving through a community and he drove on the sidewalk and he broke it. So if you're looking at this and you're trying to figure out, can we enforce this? Can we make him pay for this sidewalk? My answer is going to be depends. It depends if you've got a picture of the sidewalk before he drove on it, and you can tell me that, and you can say, I took this picture last week because I was out there with the board doing inspections. He was seen this week driving down the sidewalk, and now this is what it looks like. So now I have a before and after. Because right now, all I've got is a picture of a sidewalk. Even if I had a picture of the guy driving on it, it wouldn't prove his driving on it broke the sidewalk. I have to have the before with it not broken, him driving on it, and then it showing being broken. You've got to have the steps of how do I know something happened. So you got to have before and after photos. So when you guys are talking to your boards and you're thinking about doing walks through the community, taking photos during those walks, throw them in your file. You might think it's a waste of time, but you never know when you're going to run into a circumstance where somebody's going to do something like this. And I'm going to say to you, do you have a before picture? And you'll go, hey, I did that walk and I took pictures. And that might prove our case. Okay? How about a photo like this? This photo was sent in to show that the fence needs painting. Can you tell if the fence needs painting? Because the homeowner's response to this photo is, look, it's painted. It's stained. See, it's brown. What's the problem? One of the things that often comes up in cases when we're in court is trying to show to the court the standard of care that should be taken by a homeowner. If in fact I was going to court with this photo on the lawn, this would be awesome and perfect, because you can see the lawn on the left is green and gorgeous and the lawn on the right is dead. Right? I can show you what the neighbor's lawn looks. I can show you what the community looks like, what the upkeep looks like. This dead plant and this dead lawn is not in touch with what the standards are for the community, right? Knowing the standards of the community is important, especially when you're talking landscaping. So when you're trying to show to the court, this person's lawn is not what it should look like, having a few neighbor lawns as well when you submit the photos helps prove, look at the rest of this community. Look at how well the rest of the community maintains their landscaping, and then look at this homeowner. Now think of the circumstance when you're talking landscaping maintenance during watering restrictions, right? How do you prove that in fact the watering restrictions allow you to keep the grass green? Well, if I have everybody else on the street and their lawns are all still green, and this one lawn is the only lawn that's not, then you can prove to the court, look, all these other neighbors comply with the watering restrictions and their lawn is green. This owner refuses to comply, he's not watering, and it's not the watering restrictions making his lawn die, it's that he's refusing to water. So think a little more than just focusing in on a small area, because you have to prove the bigger picture to help you to show to a judge, because that's who's going to determine the case, is the judge. You want to be able to show to him what you're trying to prove. How about circling it? Does this help? It does in a lot of cases, but you want to be really careful with this one. When you're going to do that, when you're going to tender a photo where it's circled, the person who did the circling has to be the witness, okay? So if in fact you had a board member who took this photo and circled it and gave it to you, that board member would have to be the witness. So it's just when you present photos in court, I have to show to the court who took it, who took the photo, when they took it, because they're going to have to testify to the date they took the photo. That's something you need to remember when you're out there taking photos. Somehow in your notes, in your storage system, you have to put a date on this photo. If your camera doesn't put a date on the photo, that's fine. You can testify to it, but there has to be some way for you to remember. You guys are out there taking a lot of photos, trying to show a lot of different things. If you don't have a date on it, we're going to have problems getting it in and getting it admitted in court. So remember to know what your dates are, and then if you do feel the need to point out what you're talking about, which is the grass growing through the rocks, and drawing the court's attention to that issue, then absolutely it's fine to circle it, but know that you have to be the witness. And so if you change and you're no longer managing that property, I'm still going to have to call you back and to testify along with the current manager. Okay, so making that circle puts some additional issues onto you. So one of the questions asked is it a best practice to have the time date stamp on the photo? It makes it a lot easier for you, the witness. It's not necessary or required to get it introduced in court. So there's no requirement. It's just how you can do it. Now, I know some of my managers, how they do it is they send me the photo, and when they send it to me with their email, the email, it tells me I took these yesterday, or I took these photos 2 days ago. So when I get the photos, I can track and put the date in my system because they were emailed to me. So that might be a way you can do it in your system. Put a note in your system, photos taken, and somehow identify the photo or the file number in a log somewhere. Whatever it takes, whatever works easiest in your system, that's going to be, you know, kind of a personal preference to the manager. One of the things that you want to think about is how, I mean, we all work different. There's no perfect answer. It's just how do we both best answer, you know, remember something. A question about notices of violations. Notices of violations have to comply with the governing documents. Most governing documents are going to tell you if you have to send it by US mail or you have to send it by certified mail. One of the things that a lot of communities are trying to go with is email. One, you get the notice out quicker. Two, it's cheaper, you're not paying postage. Be careful with that. If your governing documents require certified and you're sending an email, you're not in compliance with your own governing documents. So you need to look at that. You need to make sure. The other thing, in court, and this has gone to the Court of Appeals in Colorado, when you email a homeowner a document, you do not fall within what's called the mail presumption. The mail presumption in court is if I mail something in the US mail and it doesn't come back, it is presumed it got there. There is no presumption with email. So unless the homeowner then responds to your email and says, yeah, I got it, we have no proof it got there and it can be disputed. So be careful using emails because that can backfire because we can't prove that it got there, and you just because you sent the email doesn't move it along. Okay. How about this one? I bet you not many people have a covenant that prohibits putting a couch on the roof. This is one of those that is awful looking. And if you go back to that question a while ago, really unsightly. And I'll bet you if you do have an unsightly provision that most courts are going to go, yep, we agree, that's really unsightly. But understand, not many things are this blatant, but you need to remember that there's going to be a lot of things that are going to come up that may not be in your rules. So, you know, in real estate, it's all about location. In a lawsuit, it's about the fact. We have to drill down to the facts. I'm going to have to present something to a judge. The judge is a busy person, and they're going to skim stuff. And I mean they're going to skim it. They are not going to read through it as fast or as detailed as you want. So we have to point things out to them. We have to tell them where to find it in the documents. And we have to make sure that we complied, right? So the violation letters, okay? Don't send a violation letter that says, dear homeowner, you're in violation of, and then quote an entire section out of your declaration that talks about boats, campers, trailers, whatever. And that's the letter. I understand you're busy. I do. I really do. But if your letter doesn't say, dear homeowner, you can't have your boat in your driveway, and then either reference the provision, here's the site number, or cut it and paste it into your letter, that's fine, either one. But don't miss the sentence that says your boat's in your driveway and it's not allowed. You have to be that blunt. Judges need to see very quickly what's the violation. I saw a letter the other day and it was a form letter, and that's fine. Everybody uses them. But the sentence, your boat's in the driveway, was in bold, dark. It was awesome. You could pick up that letter and go, oh, boat, got it. Okay, that's what a judge is going to do. Okay, he's going to look at it really fast, or she's going to look at it really fast. And so you want to make sure that what you want the judge to see pops out in that letter. And that is boat in the driveway, couch on top of the roof, whatever the case. Don't just quote the section that they're in violation of. Spell out what they did that's wrong. Make sure that you are giving opportunities for hearings. This law has been in place now for 7 years, and I'm still seeing letters go out and fines being imposed with no notice and no offer of a hearing. You don't offer a hearing on a fine, that fine's not going to be upheld. And instead of the court hearing and seeing the covenant violation, that court's going to go down that rabbit trail that you didn't offer a hearing. Okay, make sure you're offering hearings. Be aware of the timing on approval letters. If you have a homeowner who does submit for approval, if your documents say deemed approved in 30 days, you better be answering in 30 days or it's deemed approved. Okay, just went to court on this a couple weeks ago, and the judge was very clear. He didn't care how many times that homeowner sent the same exact plans in. If you didn't respond to every plan every time within 30 days, it's going to be deemed approved. Period. End of story. Even if they submit the plans after you've given the file to the lawyer, you have to hit that 30-day mark every time if that's what your declaration says. Okay, so look to the declaration. I have a lot of you who have boards that I want to have a lot more policies, and they're drilling down and having a second policy on this particular type of fine or that particular type of fine. If you do that, you have got to go back into the covenant enforcement policy and say, see also this special area of fines for this type of violation, because otherwise you're going to have contradiction, because you're going to have 2 separate sets of enforcement policies or 2 fine policies, and they're not going to be clear. And if you have ambiguity, the court will choose not to enforce them. Understand, in covenant enforcement, the court makes the huge burden of making sure it's clear and understandable on the association. If it's not clear and understandable, if it's ambiguous, it's not going to be enforced. And that just follows the law. Oftentimes we have issues where there's confusion on architectural issues, right? We might have some issue where it's not quite clear. People are discussing different options. There's lots of emails going back and forth. The emails might even be going back and forth between the homeowner and the architectural review committee, maybe an engineer they've hired. Stop and watch your clock. If they're going back and forth and back and forth and back and forth, right? At 30 days, send out a notice that at this point in time, the board cannot approve it. The board is still looking into additional facts. You've met your 30 days. They get no deemed approval, but you didn't shut it off. You just said, at this time, there are still questions going back and forth between the architectural committee and the owner. There's still discussions happening. So at this time, it's not approved. Don't miss your deadline because there's questions and answering going back and forth and back and forth. Question about if I want boat in the drive. If I send a letter saying you're not allowed to have the boat in the driveway, can they just move it to the street? That's a different issue. It's a good question though, because you need to not only tell them what they're in violation of. You're in violation because your boat's in your driveway, and here's the covenant that prohibits boats. And then you need to tell them what to do. Get the boat out of sight, in a garage, out of the community, whatever it is your covenants ask for. But that's the second sentence. The first letter is just identify the violation. The next question is going to be dealing with and moving on as far as how do you want to fix it? But excellent question. Had a community one time say, move stuff that was in a pile beside the house. And he did, from the front to back. So a great question. Do make sure you're asking them to do what you want them to do that fixes the violation. Okay, so we're talking about documents. We're talking about sending the notices out. Be careful again with your verbiage. Even when it seems obvious to you, it may not be obvious to a court. So don't just say there's an unauthorized landscape change. What on earth does that mean? Did they build a house? Did they, remove the all of the landscaping? Did they add complete new landscaping? Did they switch it over entirely? Put as much details if you can in it. If you're going to attach a photo, make sure the photo shows the violation. I get it. Sometimes the way the programs work, the thumbnails, it's hard. But if your document and your letter says, "Dear homeowner, you have an unauthorized landscape change," and the photo shows the garage door, there's going to be a complete disconnect. And the homeowner is going to say to the judge, "Oh, I didn't know what they wanted me to do. I didn't landscape the garage door," right? Make sure the photo you attach matches the verbiage you put in your document, okay? Make sure that there's a clear sense of understanding, so that, to use the verbiage that I used to get taught in law school, remember the acronym KISS. Keep it simple, stupid, okay? Dumb it down so that there is no way that somebody can walk in the court and go, "I didn't understand," right? You want to make sure that anybody could understand this letter. And the letter says, "You made an unauthorized landscape change because you removed all the sod and you covered your front yard in cement. While we allow xeriscaping, that's not xeriscaping." Be clear, and then show a picture of all the cement that he installed, not the front door. Be careful that what you're attaching matches what you're describing. Okay, so I talked about, we're going to have to show documents. As managers, you're going to have to testify to these documents. That's part of the proof. Proof that they're in a community governed by documents, okay? We have to prove that, in fact, I have the whole document. How do I prove that? Well, sometimes it's easy, some of the newer documents, because they're paged, let's say 1 of 20, so I get 2 of 20, I get 3 of 20. I got the whole document, right? A lot of times you have a set of documents that maybe your board retyped because it was on microfiche and nobody could read it, right? That set of documents, that cleared set of documents, that's what's on your website. But that's not the legal document. The legal document is the document that's recorded with the clerk and recorder. And if you don't have the actual recorded legal document, we got a problem. And so that's step 1. Is it signed? Is it recorded? What about if you've got new rules, and your new rules are something that's the basis for the violation? What do we do with them? I got to have the signed rules, or I got to have the rules and the minutes that say they were approved and adopted by the board. Okay, so I need the whole package. I need to be able to prove these are the governing documents of the community. Okay, emails or letters from the owner. Did the owner email you? Did they send you a letter? Is there a plan? Was it approved? Was there an approval letter? All of those things, every one of those is a piece of the puzzle, and it shows that you're working, that you're following the course, whatever the plan is, whatever the procedures are in your community. So we have to have all of those pieces. We have to be ready to introduce them. When you, the manager, are asked to introduce them, I have to go through a litany of questions with you. I have to prove you, the manager, are the custodian of records. That means I say, where do you work? As part of your job, do you maintain the files for your community? Are these those files? Are these accurate copies of those files? You have to be the person who's going to say yes to all those questions, and then that document comes in. If you go, I don't know, none of these records are coming in, and we're not going to prove the case. Work with your attorney before you go into court, because you are the manager, are the custodian, and you're going to have to produce all this stuff. Obviously, there's some things that aren't going to be verified, like whose dog pooped in the common area. So when the homeowner mails you the picture of the poop, we all know that that's one that you're going to respond to by looking at your covenant enforcement policy and says, if I can't prove who did it, I can't take action. What about noise complaints? How do we prove a noise complaint? I really recommend on noise complaints that you respond to your person complaining and tell them to call the cops. Why? Not because the cops are going to write the charge, because a lot of times they may not, but they're either going to hear it or they're not. And if they hear it, they're an objective third party. So we've got you, the neighbor complaining, and the cop who's both going to say, the party next door was so loud, it's clearly a violation of the covenants. Odor complaints are difficult. They're extremely hard to prove. They're extremely hard to deal with because what is an odor to one person, the other person doesn't care about. Smoke coming through the vents, marijuana smells coming through the vents. Half the time, there's nothing in the covenants that prohibits smoke. Marijuana is now legal. So I can't help communities when there's no covenant violation for smoke. And just one person complaining that there's smoke doesn't make it a nuisance. That's a personal preference between one owner that the neighbor doesn't share. So the manager is going to have to try and get those two neighbors to deal with the situation, because if there's no covenant violation for smoke, the fact that it's coming next door doesn't mean there's a violation. Okay. There are lots of things that are not a violation. Smoking is one of them, right? There are lots of communities. There's nothing wrong with smoking in your unit. There's smoking in the out on your patio. That's not a covenant violation. Therefore, you can't enforce it. So we can't prove it because it didn't start off as a covenant violation. If I don't know which dog left me the pile in the yard, I can't prove it. There's no way. So when you have that neighbor who's constantly complaining about the dog poop, tell them to get you a photo of the dog doing the poop and then watch the dog and figure out which house he belongs to. Because you can't do anything unless you can prove where it came from. When we're talking about testimony, when we're trying to figure out what's going on, as a manager, you have to do prep work. Okay, you have to make sure that you have looked at all your documents, reviewed all your photos, have gone through and really know the documents, right? Because when you get on that witness stand, it's going to fall on you. It's going to be me standing behind a podium, but I can't do what's called lead you. I cannot say, isn't it true, blah, 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 blah happened, right? That's leading. You're my witness. I'm going to ask you, did you go inspect the house? Yeah, what did you find? And you're going to have to tell me. You have to tell the judge, well, I went out there and it was a dump. The weeds were 4 foot tall. He hadn't mowed. He hadn't watered. But that's on you. And that means you have to have looked at your notes, looked at your photos, and be ready to tell the judge the story. Obviously, you want to dress in a way that's not going to offend. We don't know who, right? We don't know which judge is going to sit on this bench. A lot of times they switch, they move around. So you want to wear something that says, I'm a professional, okay? I don't have to have you in a suit, but I don't want you in shorts and a flip-flop, okay? You need to come to court just like you would impress, you're going on an interview for a job. How are you going to impress them? How are you going to prove you're professional? That's how you dress. When you walk in, you don't get to take your papers up to the front to testify with. So you have to have research in advance. Because if you take all your papers up there, they all get given to defense counsel. And I can guarantee you probably have a lot of notes you don't want the defense counsel to have, okay? Don't use acronyms on the stand, okay? Don't get up there and say, well, they didn't pay their HOAs. They did not pay their assessments. They did not pay their dues. They are not HOAs. This judge does not live in your realm. He sits on a bench and he hears everything that comes in front of him. Make sure that you are not talking in a vernacular that only people in the industry get. All right? Attorney's fees. Remember that your client very much wants the attorney's fees paid back. He wants to see them coming in. And so because he wants to see them come back, you need to be aware of them and you need to know, how you're going to testify. Because again, as the manager, you're going to have to take the stand along with the attorney for the attorney's fees. So most of the courts are giving about 80, 85, 90% of the attorney's fees. Most of them are going to take some off the top. So you want to make sure your boards understand. It is not you're going to get every dime back. That's just not going to happen. And you shouldn't tell them that they are, because they won't. And you, the manager, are going to have to take the stand. What kind of questions are you going to ask? How do you, the manager, approve attorney's fees? The attorney is going to take the stand. So if I'm your attorney, I'm going to take the stand and I'm going to say, I was hired. Here's how many hours I work. Here's what my hourly rate is. But then you're going to take the stand. And you're going to be asked, do you work with more than one law firm? Do you know what the different attorneys charge? Do they charge about the same amount? So are these fees that are right in front of us today, are these reasonable? Are these appropriate? And if you say no, one, you're not going to recover them. So understand that you're going to have to answer the questions that, one, you know what the other fees are, and two, that these fees are appropriate and that your board found them to be appropriate, which is why your board hired whatever attorney you have in front of you. But that's your testimony. You're going to be the one who's have to do that. You need to know that, in fact, there's this thing called the American Rule. The American Rule says attorney's fees are only awarded if there's a statute, meaning your client's a Kiowa-based community, so there's fee shifting, or the declaration says there's fee shifting. If you don't have one of those things, those attorney's fees for that lawsuit that we're trying to get pushed through aren't going to be paid. So you need to know that up as well, and that's part of the proof that we have to bring to the court. And I have a few more questions here. Question about weeds. Homeowner got a letter, said they pulled the weeds that they got the letter on, and so the homeowner thinks it should be a new violation, and not continuing on the different scale, not $25 next to the $50, and homeowner says, no, I pulled the fees that you sent me the $25 fine on, you can't send me the $50 fees now. And that's going to be an analysis by you, the homeowner, you, the manager, and your board. Did he really pull all those weeds, and are these new ones new weeds? That's going to be a case-by-case analysis on whether or not you believe if you walked in court you could prove the difference. Can an HOA that allows for vacation rentals prohibit property managers from renting in the community because they've allowed renters to violate? I think the question is, can you prohibit owners or their property managers from renting when the owner repeatedly allows for renters who don't comply? And the answer is going to depend entirely on your declaration, because when you start talking about rental restrictions, that has to be in the declaration. And most of the time the situation is going to be, you send the violation letters and you send the demands that they evict tenants who do not comply. You have fines to force that owner to pay the penalty for having tenants who aren't complying. And so the way you try and teach that landlord to pick better tenants is you have to fine them routinely. So every time there's a violation, don't just send courtesy. Send them fines, and give them hearings, and then in fact they will be more willing to work the process and make sure that they have tenants who aren't in violation. How many units must report a smoke or odor nuisance before we should send a nuisance? What we have seen of the courts is the courts don't like smoking violations. And if the owner is in their own unit smoking and you don't have a prohibition against smoking, the fact the neighbors don't like it really doesn't change that. I get that, if you've got so many people who don't like smoking in your community, then I recommend you amend your covenants to prohibit smoking. It is not a good case in court. Question, what about proving the fence needs stained? The best way to prove a fence needs stained is show a stained fence photo and an unstained fence photo and make sure the photo clearly shows the difference. So again, it's like comparing the good yard versus the bad yard. Have photos of multiple to compare. What about a noise nuisance caused by souped up car garaged? Well, that's almost the same as the noise of a party, right? How often does it happen? Does it happen that one time? Does it happen every night? If it happens every night, is it really only one owner who's complaining? You're probably not going to have a covenant violation that's provable in court because the guy who's in the car is going to say it's not happening. The one owner who's objecting to it is, and so you've got he said, she said, that's 50-50. If you're the plaintiff, you have to be at 51%. And 50-50 one-on-one is not going to make it. Question, what if you have an approval to an owner and the owner installs differently than it was approved? You have to go back to your documents. Remember that very first slide. Do your documents absolutely require the owner to install exactly what was approved? There's obviously an implication. Why would we have an approval process unless they have to install it as it's approved? However, it's better if your documents say owners must comply and install as it was approved. And if you have that, then you send the letter. Dear homeowner, yes, you submitted plans, but you did not install it as it was approved. Therefore, that's a covenant violation. So you want to, look to that. Let's see. I think that's all my questions. Question is, are ACC approval letters required, or can we just send the approved ACC form? If your form, your ACC form, has a spot on the bottom where you sign it and say approved, yes, you can absolutely just copy that and send it back. A separate letter is not required. Again, but when you're prepping for court and getting ready to go forward on this and trying to prove the violation, you would want to include the ACC as it was submitted and then as it was approved as your kind of hierarchy, your litany of everything that you had in your file. So the question on abatement is, again, when can we abate a nuisance? It's going to depend on your governing documents. Abatement means you're trespassing, right? You're going on someone else's property and changing something. So you better legally have the right to do it. And the only place that you can legally have the right to go onto someone else's property and fix something is going to be in the declaration, not in your rules. So if your declaration doesn't clearly state you can go on their property, then you can't do it. And you need to look to your declaration to see what pre-notice is required. Does the notice say, homeowner must maintain? If he doesn't, after 30 days, HOA can hire the maintenance. There's your answer. You can go on after 30 days. But that's going to be document specific to what your governing document allows for in the declaration. That's the only authority, legal authority for abatement is going to be in the declaration. Question, can you enforce a rule in a resolution just as much as the covenants? Absolutely. If you're a Kiowa community, Kiowa gives you authority to adopt rules. If you're a non-Kiowa community, look to the declaration for that authority to adopt rules. So long as your rule doesn't contradict your declaration, it's absolutely enforceable. And I think I'm out of time, so thank you, everybody. And I've answered all your questions. Again, Sean will be following up, and he'll get you the CMCA credit. And I think we're all done. Have a great afternoon, everybody.